All right, y'all. Welcome, welcome, welcome. This is week 3, Intro to Property Management. And today's subject is all about landlord and tenant laws. I'm super excited to get into the discussion. This is my favorite subject to teach because for me, I believe that we should all be educated. So whether we're currently in the industry, whether we're looking to get into the industry, whether we own our own properties or renting, I believe that we can all benefit from knowing what the laws are. All right, so I'm going to share my screen, but before I get into the segment, let us take a look at our syllabus to see what we are covering today. All right, so give me 1 second as I pull up the syllabus. Want to make sure that we are on track. All right, so today, let's see what we are covering today. All right, this is the 3rd week, and it's all about landlord and tenant laws, fair housing. So there are several sets of laws. There are federal, state, and local landlord and tenant laws. We're going to touch on that. We're also going to touch on the Fair Housing Act, as well as anti-discrimination policies, and then also lease agreements, as well as those key legal clauses when it comes to that landlord and tenant agreement. All right, so let me pull up our affirmations. Give me 1 second. All right, let's get into it. All right, so I'm now pulling up our weekly affirmations. If you do not have a copy of this, please let us know in the chat. Want to make sure that you have a copy of the affirmations. All right, so here we go. I choose to improve my life and take steps every day to achieve this goal. Can someone read the next one, please?
I can hurdle all the challenges that I encounter.
Yes. Someone read the next one, please.
I am committed to my education and will prioritize it in my life.
Beautiful. Next one, please. Kay, can you read this one?
I am proud of myself for pursuing my education.
Yes. Next one, please.
I am capable of achieving my goals.
Yes. And the last one, please. LaWanda.
My hard work and dedication will pay off in the end.
Boom. Yes, it will. Absolutely. All right. So let me get straight into our discussion for today. And again, it's all about landlord and tenant laws. All right. And one of the things that I always like to talk about and share as pertains to landlord and tenant laws is this: what you don't know can and will hurt you. So we always want to learn what we can learn. The laws are definitely going to be different depending on the jurisdiction. So the rental property, let's say for instance, you have rental property, whether you own it or manage it in DC. And then you may have rental property in Atlanta, Georgia. And then you may have rental property in New York. The laws may be different depending on where that rental property is. And unfortunately, the law doesn't really care about what we know. It doesn't care whether we break the law intentionally or unintentionally. There are always consequences for not knowing the law. All right, so here it is. When it comes to landlord and tenant law, as well as fair housing, we must always understand that things are always changing. Okay, so it's our responsibility to make sure that we know the law, that we stay compliant, because this is the quickest and the best way to avoid legal trouble. I'm not sure if you follow me on YouTube. I have a whole YouTube channel, whereas I have these discussions talking about situations and scenarios where owners are sued for thousands, depending on the fine, depending on how large the company is, some have been fined millions, owners, for breaking the law. But when it comes to this subject matter, please know and understand that in addition to state and local laws, there are federal fair housing laws. And all of these are opportunities for renters to sue owners, not just owners, but also property managers. So I'm gonna pause here before I go on to the next slide. I had a situation a young lady brought to my attention. The property manager made a mistake, did something that was not legal. The property manager was sued, and also the owner was sued. So it's not just isolated to that one specific individual. Anybody responsible for that rental property can also be included in that lawsuit. So I just wanted to make sure that I put that in there, because a lot of people don't even realize that you may not be the person directly responsible for the mistake, but when a lawsuit or a complaint is filed, they're going to name everybody who is affiliated with that property. All right, so for this conversation on today, I'm going to talk about understanding landlord and tenant laws, knowing the rights and the rules for both sides, for tenants as well as landlords. I'm also going to explore and unpack fair housing protections, learn how to best prevent discrimination and to stay compliant. And then I'm also going to break down that lease agreement and the legal clauses, which are important, because we want to break it down so that we understand the key terms, because when we do that, it protects everyone. All right, so why landlord and tenant laws matter. Laws came into place to protect the rights of both landlords as well as tenants, to make sure that I like to talk about it or say that it's a balancing act across both sides of the table. It should be balanced for landlords, and it should also be balanced for tenants. But unfortunately, in some states or cities, it is not balanced. So for instance, in Washington, D.C., the laws are strongly in favor of the tenant. And in many cases, it seems to be unfair to landlords. Some jurisdictions are completely the opposite. The laws ensure fair and legal rental practices to make sure that owners are operating legally. I saw recently on the news, and it was so heartbreaking, I think it was in Montgomery County, Maryland. An owner was renting what looks to me to have been a garage. So they fixed it up. They were renting it out. They did not have a renter's license, which is a requirement. And a fire broke out, and a couple of people died in the fire. The home did not have smoke detectors. There were numerous housing code violations, and it was a sad case. So the owner ended up getting in a lot of trouble, and the people who lived there, they obviously needed a place to stay. Maybe they couldn't afford to live somewhere else. And so it was, number one, it was overcrowded. And did I say it was a garage? It was a really bad situation all across the board. And so that's why these laws are in place. And then we always want to make sure that we're not discriminating as housing providers, as housing professionals. We never want to discriminate, because discrimination could get us into a lot of trouble. I'm going to touch on that. We're going to play a game, talk about law or nah. All right, so the three sets of laws are federal, state, and local laws. And although there are three distinct categories, I like to highlight the importance of each one and why they're different. So the federal laws, such as fair housing, it protects all renters nationwide. So you have the Fair Housing Act, you have the Americans with Disabilities Act. That's at the federal level. Also, under the federal law, you have housing programs such as the Section 8 Housing Choice Voucher Program. There are federal laws that govern how the different jurisdictions must handle those Section 8 housing subsidized programs. Then there are state laws. The state laws are responsible for overseeing the security deposit policy or the regulation, how, as housing providers, we govern security deposits, what we do with the money, when we return it to the tenants. It also, on a state level, tells us how to legally evict tenants. It governs how we implement rent increases. Now, on the local level, such as cities and counties, they have additional protection for renters. So, for instance, there are, in many jurisdictions, there are housing code violations, and there's usually an office to handle complaints. So let's say, for instance, so remember I talked about the garage that the owner was renting out illegally. He didn't have a renter's license. So on a local level, those cities and counties, they have an office. Usually it might be an inspection office that will handle housing complaints. And so if someone called to say, hey, my landlord has not made repairs, the ceiling in the bathroom has fallen, it smells like a gas leak, and I reported it to my landlord. Somebody from the local office usually will come out, investigate it, and if they find any issues, any complaints that the landlord is responsible for, and especially if the tenant has notified the owner or the property manager and they have proof, usually that housing code compliance office will issue some sort of citation, violation, or fine against that owner or the landlord, which they will have to pay. So they'll have to make the repairs, and they may have to pay the costs, whatever the fines are. It can be extremely expensive. I think in DC, which is where I am, I think that, for instance, a fine if there's not a smoke detector, I think that's like $2,000 or somewhere. It's in a high range. So that may not be the exact amount, but those fines are expensive. Now, they will give owners time or property managers time to make the necessary repairs. But if the repairs are not made, and if you don't know how to complete those forms, you could end up paying money for each violation. So let's say, for instance, you have a 3-bedroom rental property, and there should be a smoke detector in every bedroom, right? If there are no smoke detectors, you'll be fined for each smoke detector that's missing. And those fees will accumulate really quickly. So rent control laws, they do exist in some places, but not everywhere. So that's why you always want to know and understand whatever the laws are in the jurisdiction that rental property in that you own or manage. So when it comes to the Fair Housing Act, here's what you should know. The Fair Housing Act, it did come about in 1968. The Fair Housing Act prohibits discrimination in housing based on 7 protected classes. Now, just depending on where the rental property is, there are going to be additional protected classes. So I'm going to use, again, DC. There are additional protected classes in addition to these 7 here. But these are the foundational, meaning across the board in all states. These are the 7 protected classes, meaning that landlords cannot discriminate against tenants because of their race, their color, their religion, their sex, including gender identity and sexual orientation, their national origin, if they have a disability, or their familial status. Landlords simply cannot refuse to rent set on these terms or harass tenants based on these factors. I'm gonna pause here for a second. I've shared in the beginning of the class that I am an adjunct professor and have been teaching property management at 2 universities. And so in one of the universities, one of my students was married, or still is married, to a same-sex individual. So she found a rental property that she wanted to move in. She contacted the owner to say, hey, I would like to come and take a tour of your rental property to see if we could rent it out. And the day that she showed up with her wife. So her wife was in the car. She went to the door, she met the owner, and she says, well, let me go and get my partner so my partner can, see the place with me. I'll be right back. So when she came back with her wife, now all of a sudden the owner remembered, oh, you know what? I'm sorry. I just realized that we rented this property out. She didn't say all of that before she realized that it was a same-sex couple. That's discrimination. And I did tell her that she should file a complaint against that owner. She actually did file a complaint and she won the case. And the laws are set up in a way whereas, remember I said, what you don't know can and will hurt you. That's why this is my favorite subject to teach, because I come across cases all the time where owners, property managers, housing professionals and providers, they make the smallest mistake. And all it takes is one. And it doesn't even have to be intentional. You can unknowingly violate someone's rights because you didn't realize that there's discrimination. And again, it doesn't matter how small or how large it is, but we're going to see, unfortunately, we are going to see more cases where tenants are filing complaints and lawsuits against owners. Tenants are now understanding their rights. When I do my lives, well, previously I did my lives on Mondays. I paused to make sure that I can teach this class to you all, but I was doing a Facebook Live every Monday, live on Facebook, YouTube, as well as LinkedIn. And every week I will open it up so that landlords or tenants, if they have questions while I was on the air, I would answer questions, give them information. If they felt like they were being discriminated against as a tenant, I provided information. Landlords and property managers, if they had questions, they can ask, and I would help them with that. All right, so let's keep going here. So when it comes to reasonable accommodations and modification, here are two things that I want you to remember. This pertains to tenants or individuals who have a disability. So whenever you hear the term reasonable accommodation, that is a change in the policy or the service, meaning that they're changing maybe they don't have like assigned parking, right? They don't have that in their policy to assign designated parking. But if a tenant comes to them and say, hey, listen, I'm disabled. Here's a letter from my physician or my doctor. I do need a parking space closer to my rental home. They're required by law to accommodate them, to change their policy or their service for a tenant with a disability. Now, when you hear the term reasonable modification, let's just shorten that to modify, meaning that is a physical change to improve the property. Here's an example. If a tenant has a wheelchair, maybe they need a wheelchair or a handicap accessible ramp installed, or maybe a grab bar in the bathroom, in the shower or the tub, right? That's a reasonable modification. So accommodation is a change to the policy or the service, and a modification is a physical change to the property. Now, when it comes to the modification, landlords usually are required to make those changes. However, if it's a situation where the modification is too expensive, the owner can say, Mr. and Mrs. Tenant, thank you for bringing your request to our attention. We unfortunately are not able to pay for the modification. However, we are granting you permission to do so. Just make sure that it is professionally done, and you'll be responsible for returning the property to its original condition when you move out. So if it's going to, in other words, if it's going to create a financial hardship, owners are not required to pay out of pocket, but they can't deny the tenant for that physical change. So here's an example. There was a young lady, she requested a grab bar in the shower, in the bathtub. And the owner originally said, okay, you know what, Miss Tenant, we're gonna we're going to grant you your request. We're going to install the grab bar. Well, the tenant didn't want the $5 Home Depot grab bar. She wanted the fancy kind with the speakers and the crystals, and that was a little bit more. So the owner came back and said, well, listen, we can install the grab bar, but this is the amount. So if you pick something in that range financially, that is financially feasible for us, we'll install it. So they kind of went back and forth. The young lady decided that she wanted what she wanted, and that's her choice. That was her prerogative. So she was responsible for paying for it, with the understanding that whenever she moves out of the property, she would have to return it back to the condition that she found it when she first moved in. So here's a key difference. Accommodations means that it's an adjustment to the rules, while modification is a physical change to that space. Landlords may be required to approve both under fair housing laws. So you can't just flat out or come out and say to the tenant, well, no, I'm just not going to do it at all. Anti-discrimination policies and property management. So here are some of the best practices to avoid violations. We always want to treat applicants equally. Even if we don't want to, we must always do it. We should always use consistent tenant screening criteria. We should never steer tenants toward or away from certain units. Here's an example. True story. There was a young lady in a wheelchair. She called to the office. She saw that there was a vacancy available online. So she called the office to schedule an appointment. And she says, hey, I'm interested in renting your property. Can I schedule the appointment for Saturday? So the leasing professional said, yeah, sure. Thank you so much for calling. We love to schedule an appointment for you to come in. What time works best? So they agreed on a time. Then the caller told the leasing agent, she says, and by the way, I am in a wheelchair. Just want you to know. So when I come, if you can help me out of the car, that would be good, because she was getting a ride share like through an Uber or something like that, right? So she didn't have somebody who was able to come with her personally to help get her out. So she told the young lady, she told the leasing agency, says, listen, I'll need some help getting out the car. So the leasing agent, bless her heart, she says, okay, that won't be a problem. So when the lady got there, the leasing agent thought that she was doing a really good thing, which she was, out of the goodness of her heart, right? To help the lady out the car. Something happened. The lady injured herself and she ended up suing the company. So I use that as a very important message, because at no point in time should we offer to assist anybody. If there's someone in a wheelchair, we can schedule the appointment the same way that we would with everybody, but we should not extend ourselves to help, because we can intend to do good and then end up getting sued. So we never want to assist. So what we should do is say, you're welcome to come. I do apologize, but our policy does not allow us to help get you out of the vehicle. If you like to keep your scheduled appointment time, we love to show you what we have available. And if that doesn't work, we are always available or willing to reschedule the appointment. All right, so providing reasonable accommodations for tenants with disability. We want to make sure that we're always doing that. So here's an example of a violation. A landlord refuses to rent to a family with children because they prefer single professionals. That's a violation. That's against the law. Let me go back to that one, if I can. Okay. I saw recently there's a lawsuit, a major lawsuit, where a company, I believe they're located in California, they discriminated against someone who has a Section 8 housing choice voucher. Not just one person, but it was their practice to deny people who had a Section 8 voucher. And they were hit with, it was over $1 million that they have to pay back. So it's not a game. It's not a joke anymore. As a matter of fact, there is a career for people to be testers, meaning that they're hired by a company to test landlords to see if they're violating the law. And that's how a lot of these landlords are getting caught up, which is why I said we're going to see a lot more lawsuits for in favor of tenants. So lease agreements and why they matter. A lease is a legally binding document. It is a contract. It sets the rules for landlords and tenants. Key clauses that every lease should include consist of the rent. How much is the rent? When is the rent due? What is the term? Is it a month to month? Is it a fixed term? Is it a long-term lease? Is it a short-term lease? Some short-term lease may be 3, 6, 9 months. A long-term lease might be 12 or more months. A lease should also include the security deposit details. How much is the security deposit? When will the security deposit be returned when the tenant moves out? The lease should always include rules on property maintenance and property use. Who's responsible for the repairs? I like to also add if pest control services are offered. Who's responsible for paying for it? That's an important question because in my rental lease agreement, my lease agreement is at least 61 pages long. 61 pages long. And it's clear who's responsible for what. So for instance, when it comes to pest control in my lease agreement, the tenants know and understand if they see something, say something within 5 days. If they see a roach, if they see a spider, if they see a mouse, if they see a bed bug, if they see an ant, if they see whatever the bug is with a zillion, quadrillion legs, right? If they see anything within 5 days, they're responsible for reporting it. If they don't report it and the property ends up becoming infested, they will be responsible for the cost of pest control. So the lease should be very clear, rules and responsibilities. The lease should also include late fees and the eviction policy. How much are the late fees? When will the late fee be implemented if the tenant doesn't pay their rent on time? Now, here are some common lease violations and how to handle them. So here's some typical lease violations: late rent payments, unauthorized occupants or pets. So these are like the most common things. Property damage beyond normal wear and tear. That's one of the biggest ones right there, the property damage. So for instance, if there's a hole in the wall, right? That is not normal wear and tear. If the oven door is hanging off the hinge, that is not normal wear and tear. If the toilet is stopped up because something is down in the pipe, maybe a hairbrush or a Barbie doll or a toy, that is not normal wear or tear. So property damage or tenant damage usually is covered, should be covered in the lease, whereas the tenant is responsible. So a lot of people ask, well, Carissa, how do I handle these type of issues? Here's the first thing that they should do. Issue a written warning first, right? So have a conversation with the tenant, Mr. and Mrs. Tenant. We are aware that the toilet was backed up. We sent the plumber. They found that there was a shoe or several condoms in the pipe, right? Or whatever's in the pipe, because I've seen a lot of stuff, right? So you issue a written warning, being very detailed with what was found. Then you also want to refer to the terms of that rental lease agreement. So, okay, Mr. and Mrs. Tenant, the plumber came out. They found a hairbrush stuck in the pipe. In accordance to your rental lease agreement, paragraph 3, section A, it say that you're responsible for tenant damage, you're responsible for the repair. You want to include all of that in the letter. You want to remind the tenant of their responsibility, what they agreed to, because again, that lease is a legally binding document. And you want to always document everything in case you do have to go to court, because it's not what you know, it's what you can prove. And so if you have to take a tenant to court, or if you have to represent an owner who's taking a tenant to court, you want to make sure that you have everything in writing. That includes pictures as well as videos. always be professional and never retaliate, because retaliation is also against the law in many places. So just because a tenant cuss you out, don't like you, they call you every name other than a child of God, right? They can just go way left in off the deep somewhere. You still have to be professional. So when it comes to evictions, there is a legal way to do it. I always like to emphasize that evictions must follow the legal process and the procedures. Landlords cannot lock a tenant out. Landlords cannot change a lock. That is an illegal eviction. Just because they don't pay their rent, just because there's been some sort of issue at the property that doesn't make you feel warm or fuzzy, it may be disturbing other neighbors or the community. Changing the locks is the illegal eviction. As wrong as a tenant is, if an owner changes a lock, the tenant can sue that owner. Landlords cannot shut off utilities. Remember back during the COVID time, 2018, 2019, there were a lot of cases where landlords turned off the utilities because tenants were not paying their rent. That is illegal. Tenants have the right to essential services such as utilities, electric, gas, and water if the owner is responsible for paying those things. Now, if it's a tenant's responsibility, then by all means, if the utilities are cut off, the landlord does absolutely nothing because that's not on them. That's on the tenant. Too bad, so sad. All right, so removing tenant belongings without a court order. I had a young lady who I hired, bless her heart. I was on vacation, and I don't know why this young lady felt so compelled to. There was a tenant who was scheduled to move out. Now, the young lady absolutely hated that tenant. So I had gone on vacation. I think I was gone for a week or something. I don't know, but I was gone for a week. And I was confident knowing that this young lady knew enough to be the second person in charge to run that property because she was really good. I came back and found out that not only did she change the locks, but she had the young lady's stuff trashed. She had a company to come and remove all of the young lady things. So the young lady came back, and now I wasn't immediately made aware of it. So the young lady came to the office because she went to the apartment with her key and the key didn't work. So she came in upset, asking if the locks were changed. And I didn't know that the locks were changed. So of course I said, well, no, we can't change the locks. I said, your key should work. So the young lady, she pulled me to the office. She said, I need to let you know that we cleared her unit. And I said, well, what do you mean we cleared her unit? Right? Like, no, we did not, because I was not aware of whatever you're talking about. So I'm gonna need you to explain this to me. Like, I'm responsible. So she told me that she went on social media, she went on Instagram, she saw that the young lady moved into a new place, was having a housewarming and stuff like that. And so she had the apartment cleared. I said, that is absolutely not what we do. That is against the law. Can I tell you, I was so afraid. I was afraid that that lady was going to sue me. I was going to lose my job. And I was on vacation. So I talked to the young lady and I asked her, if she had moved. She says yes, but she said she didn't have transportation, which is why she couldn't get back to get her things. She's back and forth on a bus and getting a Lyft or getting an Uber. And I felt really, really bad. So the young lady, of course, ended up losing her job. But this is why this is one of my favorite subjects to talk about, because there's a lot of things that people don't know. All right, so steps to a legal eviction. We must always provide a written notice to the tenant, right? We must file an eviction lawsuit with the court. We must actually go to court. Now, it might be in person, it might be virtual, because some court cases are held online. Now, if the court grants an eviction, the court will now tell you, okay, well, you have your judgment, you have your writ, you can move forward with evicting the tenant. These are the legal steps. Now, just depending on the jurisdiction, it might be an extra step in there somewhere, but this is a foundational practice here. All right, so we're going to get into prohibited practices. All right, so discriminatory advertising. Here's a situation. A landlord posts an ad stating no families with kids, singles or professionals only. So the question is, what Fair Housing Act violation occurred? So if you can unmute yourself, let me know. So we talked about fair housing laws, right? Does anybody remember what protected category?
Was it familiar, something with the family, familiar?
Familiar status.
Yeah.
Absolutely. Yep. So how could the landlord rephrase this ad so that it would be legal?
I have no clue.
The easiest thing to do is just to advertise what is available. No mention of families, no mention of kids, no mention of singles, no mention of professionals. Just, okay, we have a 3-bedroom available for rent. That's the easiest thing to do. Just give information about the property. Okay, so here's one about tenant retaliation. Here's a situation. A tenant reports severe plumbing issues to the local housing authority. So the tenant is complaining against the owner. The landlord is upset about the complaint and immediately issues an eviction notice. What legal protection does the tenant have? Does the tenant have legal protection? So remember, I said that we can't retaliate. So just because a tenant makes a complaint does not give a property manager or an owner the right to try to have them evicted or to not make repairs. That's definitely against the law. All right, so let me see here. All right, so let me do this. I am going to let me see, was there another one? There may have been another one. Okay, didn't realize. Okay, so here's another one, illegal lockout. Here's a situation. A tenant is behind on their rent, so the landlord changed the locks while the tenant is at work, leaving all of their belongings inside. What law was violated?
You can't lock a tenant out.
Absolutely, absolutely cannot lock a tenant out. Did that owner follow the proper legal eviction process?
I don't know what's in the lease.
Good question. But now I always say, look at what is in the lease, but unless they have gone to court, that would be an illegal eviction. So that's not the legal process. But if it's in the lease and the court will allow it, then yes, you have to always look at what's in the lease. All right, so here's another one. Refusing reasonable accommodations. So a tenant with a mobility disability requests a designated parking space close to their rental home as a reasonable accommodation. The landlord refuses, saying, I can't change parking spots for just one person. So the question is, what law was violated as it pertains to the fair housing laws?
Reasonable modification?
Reasonable accommodation, yeah,
Accommodation, okay.
based off of disability.
Okay.
Yeah.
I'm getting those
Absolutely.
mixed up, accommodations versus modification. Okay, all right.
But you're doing good. All right, so withholding the security deposit without cause. So here's the situation here. A tenant moves out, leaves the unit in good condition, The landlord, however, refuses to return the full security deposit without providing an itemized list of deductions. So in other words, if we're not going to return the security deposit, we must provide the tenant with a list with a reason as to why we're not returning all of their money. So the landlord refuses here and refused to provide that itemized list. So the question is, what are the tenant rights?
I mean, they can sue the landlord for their
Absolutely.
deposit.
Yep. Yep. What should the landlord have done differently?
Provide an itemized list.
Yep.
Why you keeping it?
Right. Can't just keep the people money and not tell them why. But hey, people do it all the time. Listen, you might be surprised at what happens, but yeah, can't just keep the people money, honey. All right, so let's see here. Let's do a quick recap of some of our key takeaways for today, and then we're going to get into a little fun thing, the law or not. So it's always important to know the laws, the federal, state, and the local regulations, because it protects both the landlords and tenants. I shared about the fair housing and how serious that is. Discrimination can result in lawsuits and fines. I talked about the lease. A well-written lease prevents disputes and it protects both parties. Then I talked about how to handle issues professionally, which is why we always want to document everything. And then we always want to follow the legal eviction process. All right, so let me stop sharing my screen here. Let me come on screen. Hey, Miss Fitzpatrick. All right, so glad to have you on. All right.
Question.
Yes.
So you talked about a lot of situations or scenarios where like a leasing professional could possibly be sued. I know in other professions they have like insurance policies for like the professionals. Is that type of insurance available in the leasing profession so that if you happen to get sued, because like, are you personally being sued or can you personally be sued or I don't know.
Great questions. So let me answer the first about the insurance. Yes, the company should have insurance. It's called E&O, errors and omission. They should have insurance, which would cover situations like that. Now, to answer your second question, can they sue you personally? They can sue the company and they can sue you personally as well. You can be named in the lawsuit in addition to the owner, in addition to the company. So everybody involved absolutely can be sued. Great questions. All right, so let me take a look at my comment section here. Is there a way to prove that, or is it more so a he say, she say basis? Just curious from the tenant side. But when they show up, how do we mention it to them? I am not sure which slide you were referencing or you were referring to. Can you put in the chat box, Ms. Williams? If you remember, I do apologize, regarding discrimination. Great question. How can we prove discrimination? It's if the tenant has evidence, if they have proof, if they recorded a conversation, if it's in writing, then that would prove their point. But it's always usually he said, she said. Now, if it's a tester, so remember I talked about there's a whole career of testers. That's all people do, right? So if a tester comes out and they find that you have legally or you have discriminated, then that's proof. So here's what it looks like when you're being tested. And I had a situation where I was tested maybe 2 years ago. And I laughed because like I teach this stuff, right? So it was funny to me that someone would send a tester to me. I thought it was fun. but I know the right thing to do. So when a tester comes out, it's going to be two people. So one person might be, they're not going to be the same, but they will ask the same question. So the first person who came out was a Spanish guy. Him and his girlfriend came out. The second person came out was a Black female, right? So the Spanish guy and his girlfriend, they kind of like, they were a little bit late for their appointment. They didn't have all their stuff together. The girlfriend was on her phone. And so testers, they'll ask the same questions. They'll ask, well, what kind of people live here? Do students live here? The laws prohibit us from answering those type of questions. We should never answer that question. Or if we do, we can say something like, people who have completed the background check or people who meet the criteria live here. But we can never say, oh, elderly live here or young people live here. We should never answer, do students live here? See, we don't want to do that because the laws don't favor us if we answer those questions directly. Or we can say, to make it even simpler, I apologize, but I'm prohibited from answering that question. Anybody who meets the criteria to live in this rental community lives here. And so the Hispanic guy with his girlfriend, they came in. I took him on a tour of the apartment building, took him on a rooftop, answered all their questions. So I didn't think anything of it, like, okay, so they asked what kind of people live here. Not a problem. So now when the other young lady, the Black girl, African-American girl, she came in same day, same questions, right? And because the first couple, they were running late, it pushed me behind to the second person. And the second person asks the same questions. And so that's one of the things they're going to do. They're going to ask the same questions. Their income is going to be about the same, right? So it's not going to be like a big difference. The only thing is going to be different is what they look like physically. And so when I recognized it was a tester, I just kind of smiled. I looked at the young lady and I smiled. She was very professional, very polished. Now the Hispanic guy, he was like casually dressed. The girlfriend had on a little skimpy thing or whatever. Didn't matter to me, none of my business. People can say or do whatever they like. As long as they meet the criteria, as long as they can afford to pay the rent, their credit is good, they check off all the boxes on the list, fine by me. So when the young lady, she looked at me like, why are you laughing? Why are you smiling? Then I told her, I said, I just wanted you to know that I teach property management, so I understand the situation. So she just looked at me. She couldn't confirm or deny it, but I knew right then and there was a tester. And if you have been found guilty by a tester, then that is proof. But if it's just a he say, she say, one-off type of situation, is just your word against their word. So that's why we always want to treat everybody properly. All right, so let me do a quick test here. All right, so this game is called Law or Nah. So I'm gonna ask a question or make a statement, and then you tell me if this is the law or nah. So here's the first one. You understand? You get it? Can you give me a thumbs up if you understand it? Got it. Okay, beautiful. All right, so here's the first one. A landlord can evict a tenant for having overnight guests. Is that the law or nah?
No.
All right. Nah.
Oh, just saying no. Oh, okay.
You can unmute yourself. That's fine. Okay, here's another one. A tenant has the right to withhold rent if the landlord doesn't make critical repairs. Is that the law or nah?
Yeah, they can.
Yeah.
But they have to do certain things in order to do that. Like they have to have proof. They got to put their money in escrow. They can't just not pay rent, and you got to show that the landlord is not doing his job.
That is the law. Absolutely.
So how do you do the escrow?
So if a It just depends. So an escrow account is just simply an account that collects interest. So you can set it up or the tenant can set it up. So for instance, Ms. Dunmore, let's say I'm renting from you and I decide that I want to put my money into an escrow account because repairs are not completed in my apartment, right? Or my house.
Mhm.
So in that case, I'll go to the court, let the court know, listen, Ms. Dunmore is my landlord. I know that she's new, but she hasn't made the repairs. And so I want to put my rent money in the court escrow or court registry.
Okay.
Yep. All right, let me see your comment. Civil court, do it before, you had to do it before, had to sue the landlord before, didn't want to, but had to. And unfortunately, sometimes that's the situation. And I know a lot of people don't want to have to go to court, but you have to do what you have to do, right? At the end of the day, you have to look out for you at all costs. All right, here's our next one. A landlord must give 24-hour notice before entering the rental unit. Is that the law or no?
Law.
I would say no. What if it's an emergency?
Okay, see, that's why we're having these type of conversations. So that is the law. However, there are situations in case of an emergency. Now, let me just also add that that's true in most jurisdictions. Some areas have changed. So in some places, it may be 24 hours. In others, it might be 48 hours. But there is an exception definitely when there is an emergency. All right. Glad you all caught that. Okay, so here's our next one. It's illegal for landlords to charge extra rent to families with children. Is that the law or no?
Nah.
Nah.
Nope, absolutely not. Everybody got that one right. That violates the Fair Housing Act. She said, I wish they would. Okay, so, but yeah, that violates the Fair Housing Act off of familial status. So here's our next one. Tenants can be evicted just for calling the city to report housing code violations. Is that the law or nah?
Nah. Landlord will get in trouble for that one.
Yeah, absolutely. Absolutely. Okay, let's keep going. We have a few more here. Landlords can ask about your religion during the application process.
Nah.
Everybody got that right? Nope, absolutely not. Nah, they can't do that. Okay. Here's our next one. A landlord can require tenants to have renter's insurance. Is that the law or nah?
That's the law. They can.
Yeah.
Yes, if in that state, if that's allowed, because in some areas you can't make it a requirement, but you can recommend it. So like in DC, DC can't require, but they can strongly recommend that tenants get insurance.
So a tenant could refuse?
Yeah,
Oh, okay.
yeah, they can. And in that case, usually what I'll do is in the rental lease agreement, I have a clause in my 61-page lease agreement. I have a clause that I ask that I make sure that they initial. I explain to them that if anything happens to the rental property, if it's theft, fire, flood, vandalism, anything that happens, the owners or our insurance does not cover their belongings. If their refrigerator goes out and all their food is spoiled, unfortunately, our insurance doesn't cover that. I have them to initial it, right? But if it's a situation where maybe the refrigerator has gone out and they don't have any food, I've come out of my pocket to make sure that tenants and their family can eat because that's just my heart, but it's not a requirement. Okay, let me see the comment section. You said it's recommended in Minnesota and Georgia, not required at least in the counties you've lived in. Yeah, and see, each jurisdiction has its own, they all have their own set of policies. Okay, let's go to our next one here. If the lease doesn't say anything about pets, tenants can automatically have them. Is that the law or no?
Depending on whether the landlord likes it or not, because you can't just be bringing pets and stuff into people's houses.
But if they didn't say anything about it, then I would think that, hey, I don't know. That's a
Now,
good.
this one is a little tricky. I would say no, but here's the thing. If it's not in writing, you cannot enforce something that does not exist.
Okay.
So that one is a little bit tricky. But it's definitely not the law. All right, so here's our next one. Landlords can reject an applicant because they've been arrested. Or landlords can automatically reject an applicant because they've been arrested.
Arrested? No. Maybe convicted?
Yeah, I
Anybody
agree with
else?
her. Yeah. Arrested,
Okay.
no, but yeah, convicted, yeah, but
All right,
I would
so
say no.
okay, I see your comment. I see your comment. So HUD gives guidance, and it is definitely a discouragement for landlords to automatically deny someone because they have been arrested. As a matter of fact, some places have even made it illegal to run their background check.
Mm.
Yeah, I mean, so for instance, we can, in DC, we can run a background check, but we have to go through the first part of the application phase first. And if they meet that criteria, we have to conditionally approve them, right? And then we run a background check. And the laws are just so different in a lot of areas, which is why we have to know what the laws are. But no, we can't automatically deny someone because they've been arrested. So great response, everybody. All right, so here is our last one of the evening. Security deposits must be returned within a specific time frame after move out. Is that the law or no?
Yes, it's the law.
All right. That is the law. So it just depends on the jurisdiction. It might be 14 days, it might be 30 days, it might be 45 days, but landlords are required to return security deposits within a specific time frame after tenants move out. All right, so that is all I wanted to share today. Kay, can you drop the link for the newsletter? And then can you also drop the link for the slide deck that I shared, because I want to make sure that you can all go back and look at what we discussed, the prohibited practices. And if you have any questions, so that's the link there, please check to make sure that you have access to it. That's the newsletter. And she's getting ready to drop the link for the slide deck that I shared as well. Was this helpful today?
Ooh, I can't get back.
Yes. I mean, being
Yes.
as
Oh.
though, being as
I thought
though,
my mic was already
we
on.
all probably been renters before or something thereof. I mean, a lot of this stuff is pretty familiar, especially
Mhm.
when it comes down to understanding your lease and all of that. It's just giving us, I guess, a perspective from an actual property management point of view versus being a renter. So, I mean, it all goes together.
Mm-hmm. Okay, all right. And that's the goal. I mean, I recognize that some are tenants, so whether you own, whether you rent, it's important for us all to know the laws, both sides of the aisle. Because maybe, let's say you're renting, and I'm not asking, but maybe you're renting and then something happens. I want you to know what the laws are that protects you. And if you have any questions, you can always ask me. I'll provide you with resources, or maybe you know someone who's going through a situation. You can share this information. You can share the things that we discussed in class today. Yep. So that's why I love this session here. Okay, so Kay, thank you. I see that you've dropped those links, the newsletter, as well as the slide deck. All right, ladies, my time is up and I absolutely thank you for yours. We are, I'm working on uploading the prior classes, making sure that I get it on YouTube. I have the first class up. I'm going to send that link out. And then the second class should be uploaded as well. So if you have any questions, please email me, please reach out to me. Please have an amazing week and I look forward to seeing you all next week.
Thank you. Good night.
Good night.
Good night.